One of our favorite secret weapons for problem solving and negotiating is local real estate attorney Brian Lytle. In this series of Get Smart, Brian shares insights on price and financing.
Hi, I'm attorney Brian Lytle, and in today's Get Smart segment, I'm going to take a look at the price paragraph and the financing paragraph under the contract. Just to remind you, in the big picture, this is not specific legal advice. Each situation is always very fact-dependent. Rather, this is a broad overview. And I want to point out that while this segment is designed to apply to the three contracts used in the Liz Moore and Associates geographic area, that is the RAIN contract, which is used on the Virginia Peninsula, the CVR contract, which is used in the Richmond area, and the VR contract, which is used in the Williamsburg area, each handle price and financing a bit differently, and in some cases rather differently. And I'll try and point some of those out, but I want to refer you to the specific provision in your contract. All of these contracts are fairly drafted for both buyers and sellers, so that's the way that a Liz Moore and Associates agent can use the same contract whether he or she represents you as a buyer or represents you as a seller. So again, the purpose is to give you a broad introduction to the price and financing terms, and there are other segments that drill down on other provisions of the contract. But if you have any questions or concerns, ask your Liz Moore and Associates real estate agent, and he or she can direct you. So let's take a look at one of these provisions, which I've pasted here. And the first part is we're simply noting the purchase price. And that is what you would think it is. It's simply the total amount that's going to be paid for the purchase and sale of the property. If that's $500,000, then you write in words, you write $500,000 here, and then you put it in decimal form here, noting that it's paid in cash or by cashier's certified check. If you're financing, then of course the lender will provide hard funds. That goes directly to the settlement agent. The amount of money that you as a purchaser bring will need to be in the form of almost always folks get cashier's checks, and that's made payable to the settlement agent. If you close at Lytle Title, for example, the buyer's cashier's check would be made payable to Lytle Title and Escrow. If you have any questions about to whom the check is made payable, ask your Liz Moore and Associates agent or your settlement agent. So that's pretty straightforward. The contract then is typically going to describe how that money comes about. And for example, if the buyer is getting a loan, then we're going to note that the buyer is obtaining. There are almost no assumptions these days, so the buyer is going to be obtaining, and then we're going to say what kind of loan. Is it a conventional, FHA, VA, VHDA, other? So what kind of loan the buyer's going to obtain. The language notes by a first deed of trust. Most people refer to that as a mortgage. Technically, there's a difference between a deed of trust and a mortgage, but here in Virginia, we use deeds of trust. But it's okay to call it a mortgage. It's just easier for most people. And you're going to note here the amount you're borrowing. If you're getting $500,000 or you're buying it for $500,000 and you're putting 10% down, then that's going to be a $450,000 loan plus the $50,000 that you're going to need to bring in closing to get the $500,000 you've noted up here. The buyer can put an interest rate cap. That's that language here. And, if there's any point caps, that sort of thing, then that can be listed. So that's the basic provision. And again, the three different contracts handle this, lay it out a little bit differently. The important part is that it's done accurately and that you verify it. I know that sometimes it's a little bit unknown at the time of close or the time of contract. The offer is written by the buyer. Might be unknown exactly how much you're going to be borrowing, but you really need to put that down, or pin it down, I should say, and talk to your loan officer about it, because writing TBD is generally not a good idea. It's definitely not a good idea for a seller to allow it, but I'm not even quite comfortable with a buyer doing it, because contract has to be specific in order for it to be enforceable in court. I mean, if a judge reads it and says, look, I have no idea what the loan contingency was here because it just says TBD, it's possible a court rules there was no enforceable contract because there was no meeting of the minds. Each of the contracts will then have language that specifies the purchaser's obligations in connection with getting the loan. And this does vary quite a bit among the contracts. This is one such paragraph, but they're all basically going to have the same sort of obligations. First of all, there's going to be some obligation about how quickly the buyer needs to make the application, typically within 5 days. That's certainly in this particular clause, that's the note. Some might say 3, some might say 7, but the point is, take a look at it and know exactly how long or within what period the buyer has to approve. And the contract usually says that if the buyer doesn't do that and pay the appropriate required application credit and appraisal fees, then the seller has the right to terminate the contract. The contracts all have language indicating the buyer has to move forward and pursue the loan in good faith and with due diligence to cooperate with the lender. If the lender requests documents, the buyer needs to get on that and provide them quickly. And again, if a buyer doesn't do that, then the buyer is going to be in breach. The seller is going to have the right to terminate. All of the contracts are going to have language to some extent obligating a buyer to notify the seller whether there's been a loan denial and to provide certain information in connection with that. And if the buyer's duties contingent upon financing, then obviously the seller is entitled to know if there's a rejection and to be able to satisfy himself or herself that the buyer did act in good faith and with due diligence and did that which the buyer obligated the buyer to do. Each of the contracts will have language that allows the lender to share information with the listing side, and that's so the seller, the listing agent, can keep track of the progress of the loan. And some of the contracts, particularly the Virginia Realtor, the VR contract, requires proof of funds within a specific period of time. And what that means, if you remember my example, the sales price is $500,000, the buyer's borrowing $450,000, which means $50,000 needs to be brought to closing. The VR contract obligates a buyer to provide proof of that money, that $50,000, within about 15 days. And if the buyer does not do that, then the seller has the right to terminate the contract. Lastly, there's going to be a provision regarding an appraisal. If the buyer's getting a loan, may or may not be. It's certainly going to be the case on an FHA and a VA and a VHDA, basically any of the government-backed loans. But there's no inherent law that says you have to have an appraisal on a conventional loan. So if a buyer wants that, then make sure that that's included in the contract, either directly or by addendum. For example, in the Williamsburg area with the VR contract, there's no automatic appraisal clause, but that's a bit different in the other two contracts that I mentioned. So from a buyer's standpoint, make sure the price and the loan amount and the type of loan are done correctly, that all that information is correct. and know that you need to pursue getting your loan quickly. Make sure you understand what time periods apply and that you get them done. From a seller standpoint, know that you have the ability, really through your real estate agent particularly, to track and make sure that the buyer's doing what the buyer agreed to do in terms of applying for the financing, paying for what needs to be paid for, and taking the action to get the loan. That's so that you're not strung out over an extended period of time only for the loan to be denied based on the buyer not doing what the buyer was supposed to do. So that's a very quick, broad brush look at price and financing. Again, as I mentioned, the devil's in the details in the contract, and you need to read those paragraphs. And if you have any questions or concerns, talk to your Lismore and Associates real estate agent, and he or she can guide and direct you accordingly. Thanks, and have a great day.
Be sure to subscribe and turn on notifications for our next installment of Get Smart with Brian Lytle.